afternoon, committee. Hello, everyone. I've got some feedback. I got to get stopped. No, I think I'm better now. Okay. Sorry about that. We'll open the hearing on House Bill 2245. Revisor Wagner, would you brief us, please?
Yes, Mr. Chairman. House Bill 2245 would permit the division of vehicles to collect emergency contact information as part of driver's license records, and also allow law enforcement agencies to use that information in cases of emergency. Subsection A requires the division by no later than July 1, 2022 to maintain its files a record of the name, address, and phone number of individuals authorized to be contacted by the holder of a valid driver's license, instruction permit, or a non-driver's identification card. Subsection B goes on to state that these records will be confidential, except as provided in KSA 74/2012, which that statute provides a general prohibition from the division to release motor vehicle records, except for specific situations on request. The license holder or an authorized agent may also access that emergency contact information, obviously, to change it or view who their contacts are. The bill goes on to state that the information can then only be accessed by a law enforcement officer in Kansas or another state, and only for the purpose of contacting that emergency contact individual to report the injury or death of the license holder. The bill further instructs the division to design license applications in a way to allow an applicant to provide this emergency contact information, provide not more than 2 individuals, and also include on a statement on the application that the records are confidential. And additionally, the division shall establish a form on its website to allow the license holder or an authorized agent of the license holder to add, amend, or delete emergency contact information. And I'd be happy to answer any questions the committee has.
Further questions for the revisor? Seeing none, thank you. First proponent I have is Representative Eric Smith. Welcome to the committee.
Thank you, Chairman Prell, and thank you for having me back to your very popular committee. I don't want to belabor this. I'm not going to spend a whole lot of time going over what the revisor has explained. Is very straightforward. You all know that what I do for a living. I'm a patrol deputy. Actually, I'm an undersheriff now, but for many years I investigated accidents and such. About 2 years ago, I had a constituent come to me and explain to me that she didn't understand why she couldn't help her grandmother or grandparent put some emergency contact information so that if she's in trouble out somewhere that they would know who to get a hold of in that case. And I said, you know, I've seen that in other states, and so that set me on a mission to look and see what other states actually include that, including having my dispatch give me information about states when they come across it that include the information. Several states do. Not surprisingly, the larger states do. Florida was one of the first. I asked your revisor to take a look and see what best would fit Kansas, and we looked at Colorado and Texas, and we agreed that Texas was probably the better model. And so that's what we set this up to do. It's voluntary, it's not mandatory, and so I think that it provides probably a very valuable, and I believe it's that way because of the conversations I've had with other law enforcement and first responders. I can tell you there have been many missions that we've been set out on by EMS and such, trying to find next of kin in very dire situations. This would be very helpful in that, and so I'll stand for questions.
Other questions for Representative Smith? Must did a great job. Thank you.
Thank you, Chairman. Thank you, committee.
Committee, I would bring your attention to written testimony in support of House Bill 2245 by Ed Klump, representing the Association of Chiefs of Police, Sheriffs, and the Peace Officers. Does anyone else wish to speak as a proponent on this bill? Seeing none, I have no opponents or neutral listed. Does anyone wish to speak as an opponent or as neutral? Hearing none, we'll close the hearing on House Bill 2245 and open the hearing on House Bill 2379. Revisor Wagner.
Yes, thank you, Mr. Chairman. Committee House Bill 2375 would enact an entirely new program called the Peer-to-Peer Vehicle Sharing Act. It's mostly new language, so I'm going to try and briefly cover each section and general points for each. So section 2, starting off, is the definition section. Just so we know kind of what we're talking about, one of the main definitions is peer-to-peer vehicle sharing, and that's defined as the authorized use of a shared vehicle by an individual other than the shared vehicle's owner through a peer-to-peer vehicle sharing program. And a peer-to-peer vehicle sharing program is essentially, it's defined as a business platform. I think it's essentially an app that people would use to, like I said, share vehicles. The shared vehicle driver is also a defined term, and that's the individual who's been authorized to drive the shared vehicle by the shared vehicle's owner. And then the program agreement is basically the conditions applicable to the transaction. So sections 3, 5, and 8 all deal with insurance provisions. Some of the key points from those sections are with certain exceptions during the vehicle sharing period, which that sharing period is the time when the vehicle is transferred from the owner to the driver. The peer-to-peer vehicle sharing program, so the app, assumes liability of a shared vehicle owner for bodily injury or property damage to third parties for uninsured and underinsured motorist or personal injury protection losses. The peer-to-peer vehicle sharing program is required to verify during each vehicle sharing period that the shared vehicle owner and the shared vehicle driver are insured under a motor vehicle liability insurance policy that meets minimum coverage requirements. Insurers may exclude coverage and the duty to defend or indemnify any claim afforded under a shared vehicle owner's insurance policy. A motor vehicle insurer that defends or indemnifies a claim against a shared vehicle that is excluded under the terms of its policy shall have the right to seek contribution against the motor vehicle insurer of the peer-to-peer sharing program. And that's if the claim is made against the shared vehicle owner or the vehicle driver. Going on, section 6 requires the vehicle sharing program to collect certain information and verify and retain records for a period of not less than 2 years. Section 7 pertains to vicarious liability and exempts a shared vehicle owner and the vehicle sharing program from vicarious liability claims that arise based solely on vehicle ownership. Section 9 states that a peer-to-peer vehicle sharing program shall have an insurable interest in a shared vehicle during the vehicle sharing period. Section 7 deals with disclosures that the program is required to make to the shared vehicle owner and driver as appropriate. Some of those disclosures are that a motor vehicle liability insurance policy issued to the vehicle owner for the shared vehicle or to the vehicle driver does not provide a defense or indemnification of any claim asserted by the peer-to-peer vehicle sharing program. And also the peer-to-peer vehicle sharing program's insurance coverage on the shared vehicle owner and driver is in effect only during the vehicle sharing period that I already kind of described. And that for any use of the shared vehicle by the driver after the vehicle sharing termination time, which is after the transaction is essentially over as far as the app concerned, the shared vehicle driver and owner may not have insurance coverage from that program. Section 11 goes on to pertain to driver's licenses and require that a peer-to-peer vehicle sharing program shall not enter into a program agreement with a driver unless the driver who will operate the vehicle holds a Kansas driver's license that authorizes the driver to operate vehicles of that class of shared vehicle, or the driver is a non-resident who has a driver's license issued by the driver's home state or country and is the legal age required in Kansas to drive. Section 12 pertains to equipment that may be installed on a shared vehicle to monitor, facilitate transactions, and states that the peer-to-peer vehicle sharing program has the sole responsibility for that equipment. The vehicle owner might also be required to indemnify for certain damage to that equipment, or if it wasn't there, if it wasn't caused by the vehicle owner, then they're not required to indemnify the program for that. And then section 13 deals with auto safety recalls and requires that a peer-to-peer vehicle sharing program verify that the shared vehicle does not have any outstanding safety recalls. And then section 14 amends the definition section in the Kansas Collision Damage Waiver Act and excludes some of those new terms from terms such as lesser would not include a peer-to-peer vehicle sharing program or a shared vehicle owner, and some similar exclusions like that. So I'd be happy to answer any questions the committee has. Oh, sorry, one more note. I would note that the effective date for this bill is January 1 of 2022.
Information. Any questions? Seeing none. Thank you, Mr. Wagner. First proponent I have is Laura Mano, Senior Government Relations Manager with Turo, and this is by WebEx. Welcome to the committee.
Thank you so much. Mr. Chairman, Mr. Vice Chair, members of the committee, my name is Laura Mano. I'm Director of Government Relations for Turo. Thank you for the opportunity to testify today in support of House Bill 2379. We have worked to draft an amendment to address concerns raised by other conferees, and we look forward to continuing to work together throughout the remainder of this process. As the largest peer-to-peer car sharing platform, Turo provides the opportunity for car owners to share their cars with neighbors and travelers alike. These hosts earn a little extra income to offset the high cost of car ownership or lessen the burden of credit card debt, student loans, medical debt. Guests who are also often local enjoy the opportunity to choose an exact make, model, and price point to suit their specific needs. Last year in the Kansas Senate, I was given the opportunity to testify before the Insurance and Financial Institutions Committee. Through that process, we were able to amend a bill that originally did not meet the standards and needs of the industry to a national model, and that received support of varied stakeholders who stand together today in support of this bill. So I'm excited to pick up where we left off. The bill before you is the result of thorough negotiation and collaboration between the peer-to-peer car sharing industry, the insurance industry, various trade associations, policymakers, and other stakeholders. This was adopted by the National Council of Insurance Legislators and is what we refer to as the NCOIL model bill. This model has been adopted in some dozen or more states since its inception. House Bill 2379 sets forth a comprehensive regulatory framework for the emerging industry of peer-to-peer car sharing. That includes robust insurance protections, consumer protections, required disclosures, record keeping, and safety language. But perhaps most importantly, it defines peer-to-peer car sharing as a distinct industry. So with the support of our insurance and peer-to-peer industry coalition, we look forward to enacting this robust model bill in Kansas to provide the safest marketplace possible for Kansans to earn a little extra income, particularly during these most difficult times. I'm of course available to answer any questions that you may have, and I appreciate your time today.
Thank you. Are there questions for Ms. Mano? Seeing none, thank you very much for being here. Committee, I would bring your attention to written testimony by Tyler Deers, Executive Director, Midwest TechNet. I have no opponents listed. Does anyone wish to speak as an opponent? I have one neutral, and that's Pat Barnes, General Counsel, KADA. Welcome to the committee. Please turn on your mic.
I'm Pat Barnes, General Counsel for the Kansas Automobile Dealers Association. Appreciate the opportunity to be here today. Our view of HB 2379 is fairly straightforward and unchanged from last session, which was SB 352. By comparison, I would say they've come a long way in making changes to that bill, but we believe our concerns can best be resolved by excluding us from this bill. We have a wide variety of business circumstances that we use in the course of day-to-day operations. We are a regulated industry. The automobile industry is one of the most heavily regulated industries, but more specifically where this comes into play that affects us adversely is in the loaner and demonstrator arrangements that we have with employees and customers in a variety of circumstances. We've tried to do things that would lessen the impact on us or eliminate us in a generalized fashion with this bill. And in working with the other people that have been expressing interest in it, we think that we've come to an arrangement that if our amendments are adopted, that it will take us out of the bill in a way that is acceptable to everyone. Attached to my testimony is a set of summary amendments that could be made to do that. They all deal with the sections of the bill that seek to define who is covered by this bill and who isn't. They deal with the peer-to-peer definitions. They deal with the vehicle sharing program agreement requirements definitions, but they're all largely the same. You won't find a great deal of variation among those sections on the parts that we're talking about. What they had done in the bill that you have before you is they had recognized that the peer-to-peer sharing arrangements could mimic and perhaps cross over into rental car arrangements and lease car arrangements. And that wasn't the intention. And so while they took specific methods to address the rental car and the lease car arrangements, we didn't feel that it went far enough and that it still encompassed our demonstrator and borrowed car arrangements. So each of these will carry on past the changes that were made to accommodate rental cars. So for example, all of them will say something to the effect of, it doesn't cover the use of a vehicle for demonstration purposes or as a leased, temporary loaned, or borrowed vehicle owned by a new or used vehicle dealer licensed under the provisions of KSA 8-2401. That's the Dealers and Manufacturers Licensing Act. So our request is that these amendments be adopted. That would retain the methods by which we operate today. They aren't methods that are comparable to peer-to-peer methods. They are arrangements that nevertheless would be brought into this bill if the amendments weren't made and have really unpredictable results for us, particularly with insurance and technical requirements for agreements and things of that nature. I would certainly answer any questions you may have.
Other questions for Mr. Barnes? Thank you very much.
Thank you, sir.
Does anyone else wish to speak as a neutral, or anyone else wish to speak on House Bill 2379? Seeing none, we'll close the hearing on House Bill 2379. Committee, it's my intention to work two bills. We had three scheduled. Senate Bill 36, we will not work today. We will work that at a later date. So just so you're aware. So we'll start with House Bill 2263. Revisor Wagner, would you brief us on that, please?
Yes, Mr. Chairman, thank you. House Bill 2263 would amend the definition of electric assisted bicycles and provide for further regulation and approved use thereof. The amended definition for electric assisted bicycle would be a vehicle that is with a limit of less than 750 watts, and there are three classes of those bicycles that are definitions are created for. Generally, the rider of one of these electric assisted bicycles won't be required to maintain insurance, the driver's license. They won't be required to register the vehicle obtain a certificate of title, or possess a license plate for the vehicle. Further, there are certain, requirements that the bike would have to be affixed with a label indicating what type of an electric assisted bicycle it is. They can't tamper with it, and also the bill provides where the bicycles may be ridden. And I'd be happy to answer any other further questions the committee has.
Other questions for the revisor? Seeing none, thank you, Mr. Wagner. Committee, what's your pleasure on House Bill 2263? Representative Ballard.
Thank you, Mr. Chairman. I move that we pass out House Bill number 2263 favorably for passage.
Is there a second? Second by Representative Hoheisel. Representative Hoheisel.
Thank you, Mr. Chair. I do have an amendment. I believe the whole committee should have it now. What this amendment does, it's actually compromise language. We heard from opponents the other day when you heard us bill, the League of Municipalities and the Johnson County Parks and Rec organization, I think is what they were called. This is compromise language worked out between all parties involved to add the clarifying for the league and the trails and trail networks for the Johnson County Parks and Rec. So this is an agreement between the opponents and proponents of this bill.
Is that a motion?
Yes, I'm sorry, Mr. Chair, I do move my motion.
Okay, there's second by Representative Helgerson. Does anyone have any questions on the amendment? Would you like for the revisor to explain them? Representative Hauser.
Thank you, Mr. Chair. I do have a question about it. This does permit trail riding on the trails and network and not prohibit, right?
Yeah, we'll go to the revisor for clarification on that.
Thank you.
Revisor
Thank
Wagner.
you. Thank you, Mr. Chairman. So yeah, in G1, it still states that an electric assisted bicycle may be ridden in places where bicycles are allowed, including highways, streets, roadways, bicycle lanes, bicycle or multi-use paths, trails, or trail networks. And what the amendment is doing, instead of requiring a notice and public hearing for a local authority to regulate or limit the use of these electric assisted bicycles, basically it's changed to the subsection shall not be construed to prevent them from regulating these, similar to how they regulate bicycles. And then if they have jurisdiction over those certain pathways, they can limit the use of those bicycles. I'd be happy to answer any further questions.
Representative Hauser.
Thank you, Mr. Chairman, for a second bite at the apple. Hey, Chris, the big paragraph here, the subsection shall be. So does this mean that a city or county or whatever does not have to regulate if they don't want to? Or how does that work?
That's correct. That's how it would work. They don't have to, but it's stating that they can, and they have the power through their home rule powers to regulate.
Thank you very much. Thank you, Mr. Chair.
Are there further questions on the amendment? Seeing none, Representative Hoheisel, you may close.
Thank you, Mr. Chair, I close.
You've heard the motion by Representative Hoheisel to amend. All those in favor signify by saying aye.
Aye.
Opposed, no. The ayes appear to have it. The ayes do have it. Is there further discussion on the bill as amended? Representative Delperdang.
Thank you, Chairman. This may be more of a question for the revisor, if I may. But I was looking down here on lines 36. No person under 16 years of age may operate a Class 3 electric assisted bicycle, on and on and on. Can you tell me at what age can an individual get a restricted use license to drive farm vehicles?
can't tell you off the top of my head, but give me a second and I'll find that.
Sure.
Okay, thank you.
I believe the answer is 14, but I'd like to hear it to verify.
That was my thinking as well, but yeah, I'll verify that by looking up the statute.
And then while you're there, I've got, the next question would be the same similar question for motorcycle use. If I'm got someone of a learner's permit age trying to learn to drive a motorcycle.
Yeah, I will try and find that quickly as well.
Okay. Yeah, I don't mean to hold you up, but I would just be curious because if we're saying no one under 16 on a bicycle, but I think we can put a 14-year-old out there with a vehicle under 26,000 pounds driving down the highways. So
Yeah, so farm permit, it looks like it can be issued to anyone who is less than 17 years of age, but is at least 14 years of age. So
Okay.
you're correct on the farm permit.
okay. And then if you on the motorcycle usage, I would appreciate it. Thank you, Mr. Chairman.
So So, and sorry, I'm trying to read through quickly. I believe by reading it that the division may issue a restricted Class M driver's license to any person who is at least 15 years of age, but that is restricted in a form. But
Okay, and I would go along with that. I couldn't remember if it was 14 or 15, but that is for a regular motorcycle that could hit the roads at 70, 80 mile an hour then.
correct, although they are obviously, like I said, restricted from normal driver's license allowances.
Sure. Okay, thank you. I just wanted to bring up that there may be some consideration there.
Okay. Anyone else have questions on House Bill 2263? We do have a motion that Representative Ballard had earlier. Would you renew your motion with the amendment, please?
Certainly. Thank you, Mr. Chairman. I move that we pass House Bill 2263 as amended favorably for passage.
Motion by Representative Ballard, second by Representative Hoheisel. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes appear to have it. The ayes do have it. I'd like to move on to Senate Bill 33. Representative Helgerson.
Mr. Chairman, I move that we favorably pass out SB 33, favorable for passage.
Okay, I got a little ahead of myself. Would is there a second for that? Second by Representative Ballard. Reviser, would you brief us on Senate Bill 33, please?
Yes, Mr. Chairman, thank you. Senate Bill 33 was a bill we heard yesterday, which provides for a new temporary display show license. There would be a fee in the amount of $100 for any sponsor of one of these display shows and $35 for any participant. And those fees are remitted to the Director of Vehicles, who can set conditions, can set reasonable, or they may reasonably require certain conditions for these shows. And the participants can participate without regard to any relevant market area or geographical restrictions. And they can also do so without getting approval from any manufacturer. And there's no sales or lease transactions that can occur at this display show, but demonstration test drives are permitted.
Are there any questions for the reviser? Seeing none? Are there any, does anyone have any questions, any comments on Senate Bill 33? Hearing none, Representative Helgerson, you may close.
Move the adoption of Senate Bill 33.
You've heard the motion by Representative Helgerson to adopt Senate Bill 33. All those in favor signify by saying aye. Opposed, no. The ayes appear to have it. The ayes do have it. That does conclude our business for today. Tomorrow, we will be working some bills. House Bill 2193, House Bill 2245, House Bill 2295, and House Bill 2379. With that, we are adjourned.